Can you hear me? Yes. Okay. So, good afternoon, ladies and gentlemen, and thank you very much for attending this session that I'll be chairing. I'm Mario Todino, Jones Day. Let me first tell you what we have on the program. We are going to discuss some of the most notable procedural developments in EU merger control, but we would also very briefly touch upon the Italian merger control system by comparison to the EU merger control system. Then we will try to address very briefly the issue of the remedies. You can, okay. Can you hear me? Now it's okay. And then we will, as I said, we will be discussing very briefly also the gun jumping issue, which is very hot at the moment. Now, as to the format, we thought it would be more lively to have a discussion, so it will be structured along questions and answers from the panelists. Now, very briefly, let me introduce to you the panelists. So on my left, Andrea Pezzoli needs no introduction. You know him very well. He's Deputy Secretary General of the Italian Competition Authority and is one of the most senior and knowledgeable officials of the Italian Competition Authority. And then on my right, Giuseppe Conte, who's official of the legal service of the European Commission. Very senior official as well, has been around and holding a number of positions within the Commission, including Cabinet Commissioner Cross. And then on my further left, we have Francesco Savino, Head of Antitrust in Hitachi Rail. And Francesco, prior to joining Hitachi, has done a lot of prior practice in a number of international law firms. Hitachi Rail, as you know, is a big supplier of rolling stock signaling systems, very strong in Italy, having acquired, about 10 years ago, Ansaldo Breda and Ansaldo signaling systems. Right, okay. So without further ado, let's start. And let's start first with the issue of the increasing complexity and sophistication of the EU merger control. The impression is that over the last years, the level of complexity and sophistication has exponentially grown, and this has reverberated, of course, in the length, in the duration of the investigations, and most notably pre-notifications, right? And why is it? Well, there are a number of reasons behind this development. First and foremost, the role of the economic analysis playing, an increasingly important role in the investigation. Of course, the new investigative technique that the Commission has been developing over the last years, meaning unfiltered direct access to internal documents, and that means a lot of requests for information regarding internal documents to be processed. A higher standard of proof, perhaps, although now we know that the Court of Justice has just announced the judgment of the General Court with regard to the standard of proof. And last but not least, very important, what we call in our jargon this front-loading tendency, which means that companies they have a preference, actually, to go in pre-notification and try to discuss the remedies beforehand, especially in very complex merger transactions. They also prefer to have investigations, run during the pre-notification. As a result, pre-notifications have become the favored venue for economic analysis, investigation, market test, and remedy negotiation. Okay? So against this background, so my first question will be, and I would actually start with Francesco, because Francesco, as you understand, is a representative of the industry. So how how do you see this tendency? Do you see pros and cons? Why is it that, in your view, businesses tend to enter into this, what I call limbo, because in my view there are problems to this tendency. So perhaps you tell us, what do you see pros and cons?
Thank you, Mario. So I should start, yes, I represent industry on this panel, but I also spent 7 years at the UK communications regulator, so I can speak with both hats on, and I see the sides of a regulator as well as a business.
Another limbo.
Another limbo. sitting on both sides of the fence, I would say. In terms of the sort of pre-notification phase, I think, Mario, was your question. Business loves certainty and predictability. The pre-notification phase, at least how it's sold to merging parties, is let's have this discussion where we're not bound by statutory timeframes, so that when it comes time for the notification, we enter into the process with a lot more certainty, both for ourselves on the regulator side, having had the opportunity to get up to speed with the facts of a transaction, the technicalities around it, the industry, etc., but also for the business. To be able to, for me, to be able to say to my senior management, look, we've had 6 months of discussions with this regulator. This is what they're telling us. This is how we can feasibly see the phase 1 review going. And so business likes that certainty. Now, this is where I'll be the agitator on the part of business. The cons are where you've had all of these months with the case team in pre-notification discussions. You're at the point ready for filing, and then the phase 1 doesn't necessarily go in the way that you'd expected it. As far as senior management, and I talk, in terms of how senior management of companies interpret this, is great, I've just wasted 6 months and my transaction has been delayed and I'm potentially late in terms of the timeframes that I'd set myself. So that's the con, is being able to achieve that level of predictability that's good for business, but then getting potentially nasty surprises when it doesn't go our way. So, how do you solve this? That's the million-dollar question. Obviously, an authority is not going to say to an emerging party, file now and you're going to get your clearance in 25 working days, for instance. But there needs to be, I think, a point of reckoning on the part of regulators in a very transparent way, which I think highlights the concerns, if they still exist, and the very real prospect that, for instance, that might lead to a negative decision at the end of phase 1. And I think sometimes, and this is probably a combination of case teams obviously not wanting to give too much away, and potentially parties to a merger who just want to see all of the positive sides of something and don't want to think about the bad potential consequences. But I think that realization has to be at the forefront of both regulators and parties' minds when they're going through that process.
Okay, no, that's fair enough. Now, however, one of the problems that I see when these cases, take ages, is that Commission can actually investigate endlessly with no check and balances. And that is the problem to me. So I'm going to ask the legal service, what are you doing there? Because after all, with all these cases that are actually discussed and negotiated, in an informal setting, that is one of the major issues that we would actually lack in that type of setting. So the check and balances that, for instance, the legal service or the chief economist team can exercise. Are you present in that type of investigation?
Okay, this is something I think might be useful to clarify a bit, because the pre-notification is not phase 0, is not another phase of the procedure. it is an informal discussion which is mainly meant to collect the information needed, and to ensure that the notification is complete. And that when the formal process starts, all the information is there, and therefore one can speed up and be more efficient in the formal process. It's not meant to replace the procedural phase, also because, as Mario, for instance, mentioned, there is no procedural setting. For instance, within the Commission, there is not the involvement of the other services, there is not the involvement of the legal service, and companies may tend to think that this is during this phase where information is supplied, this might be a good moment to exchange views, and the regulator is, the DG Comp is always open to discuss, and we are always welcoming an informal discussion, but it shouldn't be considered as a negotiation setting where a deal can be struck, because then there is no guarantee, indeed, that when this formal process starts. And at the end of the day, companies are always, it's in their hands whenever they want to notify a merger. Of course, there is the risk of incompleteness, but yet, if the information is there, and companies try to use this time, might be useful, might be efficient, but it shouldn't generate any sort of expectation, because now it's a bit funny, I have to say. We have seen around Europe, in other jurisdictions, that there is phase 1, phase 2, phase 3, post-decision negotiation, a new setting. There is a certain procedure which is foreseen by the rules. This is the real setting when everything happens. This pre-notification shouldn't be, let's say, considered too much as being part of that procedure from my point of view.
But so do you agree then at the end of the day, off the records of course, that the legal service actually is a little bit squeezed when it comes to this type of, setting, because you have no role to play, or you do play some informal role?
I think I wouldn't say squeezed, and we are not part of this kind of discussions. Of course, we are copied in notes to the commissioners, and so we have a certain within the institution, but we are not part of the discussion, so this should be really considered as a phase to collect information, to have a complete file on the table. Shouldn't be really considered as a real negotiating setting. The legal service, the other services of the Commission, because there is not only the legal service, there are other services which are associated. Ultimately, the decisions are not decisions of DG Comp, are decisions of the Commission, the College of Commissioners. Of course, DG Comp runs the show, and the Competition Commissioner makes the proposal. But this is a complex procedure, so shouldn't be considered as is another phase of the merger procedure. So the legal service is not involved in discussions, and this should really be used to collect information rather than conclude deals. Then, of course, companies try to use all the time available. We see that they like, sometimes they like informal discussion, that's fine. But I'm afraid that if there is this feeling that no certainty comes out of there, it is intrinsic in how the procedure is structured.
Right. Okay. So Andrea, let's make the link with the Italian system, because it's funny that we have a system in Italy which is just the opposite, right? So in Brussels, we have these endless investigations which take ages with pre-notification, and then after pre-notification, you have the 30 working days, the 90 working days, the extension, so it can easily take 1 or 2 years for a case of a certain complexity, even 2 years, in fact, although you don't see it, because as I said, there are no statistics, official statistics. Now, in Italy, it's the other way around, because we have very short timelines, right? The pre-notification is voluntary, and it doesn't really work. Now, there is apparently in the pipeline a reform underway, but how do you see, so if you had to, compare the Italian system to the EU system, would you be critical of the Italian system, or, of course, feel free to comment also on the EU system?
Okay, I think that, when you were talking of cases take ages, it's a completely different reality. For us, I mean, it's as Todino just said, I mean, it's a completely different story. The problem is that our procedures are too short, and this is the reason why, in a way, we might look in a very positive way at cooperative pre-notification, so the phase -1, let's say, because sometimes, I mean, when there is the will to cooperate and to collaborate with the agency, possibly you can design the remedies in a more effective way if it is the case to authorize the merger with remedies, because I mean, you probably, I don't know how many of you probably know, I mean, our phase 1 lasts 30 days at most, and our phase 2, 45 days. Finally, in the annual competition law, which is under discussion, possibly the timing of phase 2 will be extended to finally 90 days, which is at least it's a more decent duration for a deeper analysis, because I mean we started talking about complexity, and I mean mergers are becoming more and more complex, not only in the famous digital world but also in the traditional world. So don't forget, digital and Green Deal are not the only two aspects that we have to consider. So I think that possibly it is too long, the European method, but I think that we need a longer time in order to, develop the proper economic analysis that mergers, that complex mergers require. And I think that since, most of the mergers are authorized with remedies, we recently, before the COVID, we concluded an interesting study concerning the remedies imposed by the Italian Competition Authority, 73 of which were structural remedies, 45% of which were behavioral remedies. Some of them were permanent behavioral remedies, so quite complicated remedies that should be analyzed. Otherwise, you realized afterwards that the remedies was completely ineffective. So I think that we need time, and till now what happens is that the company, sometimes strategically from their point of view, the last week before the conclusion of the investigation, they present for the first time remedies which are quite sophisticated, quite complicated, technically almost ununderstandable for a poor economist. So, you have to deal with these sophistications, and 1 week time is absolutely insufficient. So timing is crucial, collaboration is crucial, because if you want to design in advance the remedies in order to reach what was said, predictability, because firms like predictability, and complexity and predictability sometimes are not good friends, because sometimes complexity requires new theories of harm, a different approach to potential competition, a longer time horizon, something which makes the assessment, slightly more discretional. And this is the reason why good and sound economic analysis could be helpful in order to create sound theory of harm, which are less discretionary, but at the same time that do not ignore phenomena which are less predictable, but at the same time they do exist. So you have to deal with them. So this is the reason why I think that something in the middle ground between the endless pre-notification, which sometimes take place in Brussels, and the too short, let's say, hit and run assessment of the Italian competition, of the Italian law, we have to find something in the between.
And do you think that would it be conceivable, for instance, alongside this reform, right, which is underway concerning the timeline, to make pre-notification mandatory? As you said, we're not contemplating these endless pre-notifications of the Commission, but perhaps a 1 month pre-notification or 2 months pre-notification in a very complex case, it would also, in my view, could help. That could be something that you could do just as a recommendation to the companies.
I mean, it could help if there is the will of the company to be cooperative. I mean, sometimes we assist to strategic pre-notification 1 week before, and as Giuseppe just stressed, I mean, it is in the hand of the company to decide when and whether notify a merger. So if you pre-notify a merger 1 week before and afterwards you notify the merger, the pre-notification is something which is absolutely formal and absolutely useless. If you want really to design the merger in order to be as certain as possible, because don't forget that, I mean, that the commission is a third party, so the proposal of the officials of the Italian authorities is just a proposal, so the commissioners are, and the president are those who take the decision. So, I mean, there is always a thing, let's say, I would like a small percentage of probability that the decision could be different from the proposal. It doesn't happen so often, fortunately, but it might happen. So, as it was said before, phase one might go in a different way if compared to what was the discussion during the pre-notification. So I'm not particularly fond of a mandatory pre-notification. I think that, I mean, when you have 90 days in phase two, you can have time to develop a deep analysis. Of course, if there is if the company wants to be cooperative in order to, let's say, design the merger in the best possible way, you're welcome. But I think that make it mandatory doesn't solve the problem.
Just saying, of course, the pre-notification is not mandatory in Brussels, for sure. It is strongly recommended, because otherwise there is the risk that the notification might be found to be incomplete if not sufficient information is provided. So it's strongly recommended. I couldn't see it mandatory, because once you make it mandatory, then you have to establish a procedure. You cannot mandate something in the vacuum without any rule. And then this would lose this, what the companies like, this kind of informality, this kind of possibility to discuss outside before the formal procedure, and so would lose a bit its sense, I think.
That's right, but as you said, yes, it's quasi-mandatory in Brussels, because if you don't do it, DG Comp is going to dump your filing form, and so it's at the end of the day, you need to do the pre-filing anyway, at least in complex cases.
DG Comp only looks carefully at the notification and would only raise issues if were to find that this is incomplete, of course, very objectively, and so there is.
Sure. Okay, let's discuss very briefly remedies, because also in remedies we see this tendency, the toughening of the Commission policy when it comes to remedies, and that is in all respects. So it's not only when it comes really to the type of remedy being imposed, typically it's going to be structural divestiture, but also the scope of the divestiture is increasingly wide and extensive, and that is very, very often based on viability grounds, meaning that, the remedy is not only meant to fix a given problem, but also then there are viability issues that need to be addressed in order to recreate, that competitive source that has been removed from the market. And then there is the other tendency that we see. The other trend is, when it comes to the divestiture processes, where now we see the exceptions, like the upfront buyer and the fix it first type of remedies, becoming the norm. So just, upfront buyer, fix it first, it means that the notifying party cannot close the transaction as long as the Commission has not approved the suitable buyer of the divestiture business. So that means, unlike in an ordinary type of divestiture process, where the Commission gives conditional clearance, the notifying party can close the main transaction and then go ahead and do the divestiture, okay? Now, the question here would be, again, we see this tendency to use these procedures as the norm, despite the notice clearly indicating that these procedures should be actually employed when there is an issue regarding the viability of the divestiture business, the identity of the suitable buyer, third-party rights involved. But the impression is that it's becoming more and more the norm. And again, I would start with you, Giuseppe, because I see there, for instance, an issue of proportionality, for instance, of fair process proportionality that very often is overlooked. And again, it's probably because there is not another stakeholder like, for instance, the legal service, a decision maker, playing a role in that respect.
On this last remark, of course, the legal service plays an important role and is checking that very carefully. Maybe just to clarify something you said, you say, okay, the remedy is not just to fix the problems, but something more. I would not put it like that. If you have a fantastic remedy, you have a divestiture business, which is fully fix the competition problem, but is not viable, this will last very little. And so that doesn't, in reality, does not serve the purpose. Ultimately, if you are putting together a divestiture business which doesn't guarantee to remain viable in the market, it will never, in the long term, solve in a structural way the competition problem. So often companies complain about that. But frankly, I do not think we can look at these two aspects in isolation, because the viability of the investment business, it is fundamental if you want the problem to be solved. We had some cases where we had some waivers were granted, and we have been now discussing defending the waiver decisions in Luxembourg, where some businesses, after having been divested, and were not viable, were stopped operating in the market, and the problem was not solved, and this gives rise to all sorts of unhelpful situations. So I wouldn't look at that. Of course, then the proportionality is looked very carefully. Somehow, maybe part of the discussion is that the big difference between, for instance, the rules in Italy and in Brussels, that as far as you portray as the Commission imposing the remedies, ultimately are the parties who present them. And so while in Italy then there is a more, I guess, this proportionality element, since there is the power to impose the remedies, then it plays a different role there, I would say.
Yeah. And Andrea, how do you see the, again, the Italian, the policy of the Italian competition authority as opposed to on the remedies?
No, I mean, the 2 points you discussed, I mean, the one of the identification of the appropriate buyer, I think that, I mean, from our practical experience, I think this is crucial, because especially in the case of divestiture of a number of different stores, for instance, in the retail sector, I mean, quite often we had the problem that at the end of the day, the acquirer is not a fit one, it's not an appropriate one. So, I mean, we have to modify the remedy, and there is a very long procedural problem before closing the assessment of the merger. So I think that, I mean, the identification of the buyer before the end of the procedure should be crucial. Otherwise, I mean, it's always up to you. I mean, there is always a possibility to prohibit the merger. It's a different story when we impose the remedy, and this is the case of proportionality. I mean, as far as I remember, and unfortunately I have been working for the Italian authorities since 30 years ago, I mean, we are being always extremely cautious in imposing something which is above the specific impact of the merger. So the temptation to solve all the structural problems of the market, also those problems which are not strictly linked with the merger that we are assessing, sometimes was a temptation, but as far as I remember, we resisted the temptation. So this is the, unless, I mean, it is up to the parties to present something more. In that case, if the parties are generous, I mean, we are welcome to accept their generous offer. But
right. And Francesco, perhaps your view from a business perspective, having in mind, perhaps, if you can also comment about this additional element of complexity that we see in the picture, meaning that, especially in the field of remedies, we see more and more a risk of conflict and clash with the remedies being imposed by other competition agencies, most notably the CMA. Now, you could say, okay, but there was also previously this risk with other agencies like the US. However, the way I see it is that the problem with the CMA is ever increasing, because after all, they decide very often on markets which are the same. And so they end up with the same remedy, or with completely conflicting remedies or completely conflicting outcomes.
Yeah, no, that's right. I think I would just start with the original point of conversation, and really all I would say there is, from the business perspective, obviously proportionality remains key, and also it's listening to customers. That is the one message that I, as someone from business, want to drive to the regulators, which is listen to the affected customers. With that, on the CMA point, yeah, I mean, we are in a new world post-Brexit. Yes, you're right, Mario. There have been times in the past where other regulators are obviously looking at the same merger as, say, DG Comp, but I think what is obviously, it was previously the CMA and DG Comp would not be looking at the same merger. That is new, but also businesses which operate in the UK are often also operating in the EU. So there is clearly a nexus between the two jurisdictions, which makes this case, I think, particular. We've obviously seen what's happened in Microsoft Activision, the case of two regulators looking not only at the same merger, but at the same remedy and reaching different conclusions. I think we are in a point, we are in a phase of evolution, I think, with the CMA, in terms of it deciding where it sits in this new dynamic and how it's going to exercise its powers. At the moment, we are seeing instances of the CMA very much not afraid to be looking at effects of a merger, say, in the EU, the exact same effects that DG Comp is looking at, and that's necessarily causing tension. It's necessarily causing potentially different outcomes on the identical aspects of a merger, and that for business is clearly a problem. That, go back to my earlier point about predictability and certainty. That how do you deal with one regulator saying yes and another regulator saying no on exactly the same elements? As I say, that's a problem. There is also, and that's obvious, I think. And as I say, I think as time goes on, I'm ever the optimist, and I think that we're going to get to a position where the CMA is going to realize its place. And I think all I'll say is in the last 6 months, I think the CMA has learnt a lot. I'll just leave it at that. But there's a procedural issue here as well, because the CMA process is quite different. And in a nutshell, if you are discussing remedies with the CMA, so much of it is front-loaded before the actual final decision comes out, far more than in the DG Comp process. So the problem that presents is, just from a very simple procedural aspect, merging parties are unable or are limited in their ability to run the two processes in parallel, and risk undermining the process on one side because they're trying to accommodate the process on the other, and that's an issue. And I think this issue of the CMA's process has been, in fact, it's been consulted on recently. And I think for me, again, from the part of business, that is something that they've really got to look carefully at, especially in light of the fact that there are only going to be more mergers where they're going to find themselves alongside DG Comp, quite possibly looking at exactly the same elements of the merger.
Okay. By the way, if there are questions, please jump in. Let us know with pleasure. We will address your question. Perhaps very briefly, Giuseppe, one point regarding gun jumping. I know that you've been involved in most of this litigation, and I find the picture quite intricate, meaning that, okay, there is for sure a toughening of the policy of the European Commission. There have been a number of judgments in that area, including Altis. But I would like you to perhaps tell us where we stand in your view, whether there is still a need of clarity, in particular when it comes to these acts of intrusion right into the management of the ordinary course of business, because this seems to be the line that has been drawn by the Court of Justice, by the General Court and the Court of Justice. And there are, however, a number of situations that are unclear to me. For instance, in Altis, we see that according to the General Court, even the right to veto the appointment of key employees could be regarded as gun jumping. And that point could also be regarded from totally different angle, meaning that a buyer wants probably to preserve the value of the business, and the fact to be able to veto the appointment of a key employee might actually impact the value of the business. What is your view in that respect?
Okay, maybe just a step back, because in fact, gun jumping now, there have been many cases, and there is a bit of this perception that the Commission is becoming more active. I would say that the standstill and ex-ante notification has always been a cornerstone of the EU merger control. There have been a number of decisions. And for me, the most important interesting development, in fact, does not come from the Commission, but comes directly from the court. And it's a bit peculiar that it came from a preliminary ruling, which normally in mergers are very rare. And recently we have seen many more preliminary rulings in the merger field, starting with Ernst & Young. Then we have seen on jurisdiction Austrian Asphalt. We've seen Tower Cast. And Ernst & Young is very important because clarifies, it is where the Court of Justice clarifies the principle, and for the first time clearly stated, somehow also clarifying some obiter in some past judgments, the role of a partial implementation, that not only in the standstill obligation captures measures implementing fully the merger, which is quite obvious, and I would say some of these recent cases are less interesting from that point of view, because when one sees the factual acquisition of control, like in Marine Harvest, it seems quite standard and quite clear. But what is interesting in Ernst & Young, that even transactions which fall short of an acquisition, of a full implementation of the merger, are caught by the standstill obligation, and therefore may give rise to gun jumping any time where these transactions contribute in full or in part, the euro de facto, to the implementation of the transaction, and as far as they have a direct functional link with the acquisition of control. This is very important. In my view, this was the basis which led to the canon judgment, which is also very important because clarified warehousing, and there was a bit of a the Commission took a position in its jurisdictional notice, but it was a bit a gray area, and now has been clarified in light of that. that even warehousing transactions are caught by the standstill obligation. Then there are situations like Altis, where indeed there are the parties, the acquirer starts exerting some rights and exerting an important direction. I would disagree with your characterization, and this is where just minor transactions, minor veto rights, which were meant to preserve, just to preserve the value of the business. In fact, the court, on the facts of the case, took a different position, and we defended that, and that indeed these went beyond what was merely needed just to preserve the value of the target. Now we know that the Advocate General endorsed the position of the General Court. We will have very soon the judgment, which is already scheduled for November, so we will know the final position on that of the Court of Justice. But I would say these are quite exceptional situations where this pre-transaction agreement went far beyond what is needed just to preserve the value of the business.
Yeah, but just to me, the dividing line between what is lawful and what is unlawful under the gun jumping rules should be that if I'm the buyer, okay, and I have a veto over all decisions of the seller/target, which may impact significantly the value of the business. This is something that should be lawful. What should be unlawful is having a say in the management of the ordinary course of business of the target. Now, my problem with Altis is that when it comes to the appointment of key employees, officials, whatever it is, the court says that would be unlawful, okay? That would be a breach of gun jumping rules because, after all, it's ordinary course of business. This is where I see a little bit of inconsistency with the proposition of the court.
Somehow, what is needed to preserve the value of the target is something somehow unclear concept. You can always say, I need that, and that, and that, otherwise the target, and then you end up running the company, and that's certainly not possible. Normally, there was the kind of major divestiture, there were transactions of that kind, which were normally considered as being some major events which would alter the substance of what you are buying, and this is understandable. When you go there, and there was a long list, it was not an individual thing, and the court viewed that all together, and you go there and you can decide on many, many, many things which is really not needed, or you cannot show that is needed, then you go a bit too far, and that's what the court somehow said. If you take any little instance in isolation, maybe you would say that you would disagree, but you should look at the overall picture.
All right, okay, concluding remarks. So, please, gentlemen, if you have any...
Let me spend just a few words about the new powers that the Italian Competition Authority have concerning merger control. So finally, we have the quotation mark, the new test, and we abandoned, and it was very painful, the traditional dominance test. It was an old friend, but finally we have a more sounder economic test. The timings possibly will be extended. We have the possibility to recall or to ask for the notification of under the threshold mergers, which is not important not only for the digital mergers, which is extremely fashionable, very cool, but also for mergers between two medium-sized parties at the local level that sometimes could have a very significant impact, but possibly everything happens below the threshold. And this is quite important, and let me conclude with a, let's say, light provocation. We have also the possibility, the power to request of information and the possibility to impose fines if a firm doesn't provide the information at their disposal. This is crucial for the request of internal documents. I mean, Mario started his speech, mentioning the crucial role which could be played by internal documents, especially when you talk about mergers, conglomerate mergers, where we don't understand why they are spending so much money for somebody who is distant in a different market, and possibly there is the reason why they are spending so much money. So the request of information in order to have an easier access to internal document could be extremely important. And finally, and this is my personal opinion, it doesn't necessarily involve the opinion of the Italian Competition Authority, I think that when in the mergers are involved large platforms or a very powerful acquirer, I think that the reversal of the burden of proof have to be seriously considered.
Francesco.
Well, before I go on to what I'd planned to say, just a sort of a plea on the back of what Andrea just said about information gathering. I think information gathering has to always be done with proportionality in mind, and bearing in mind the burden that it places on notifying parties, for instance. But beyond that, I think, as I said before, predictability and certainty are key for business, and therefore, for me, it's engagement, it's transparency, it's dialogue is what I implore every competition authority to have at its forefront when they're undertaking their processes.
Indeed, dialogue is very important. Giuseppe, to conclude.
Just to say that somehow the role of the regulator is not always easy. At the end of the day, it has to make a call. It is more likely than not that this merger, possibly as motivated, and this is being clarified now that in CK Telecom, as the correct standard of proof leads to a significant impediment of effective competition. We are often criticized if the companies or the lawyers pretend that we didn't do a thorough enough assessment, or spend the end of last week pleading to defend some merger authorizations, and then so the competitors were complaining. Sometimes we block a merger and then the parties complain. It is difficult to make an assessment. We need to be thorough, and so I understand that this may cause some worries from companies, but we have to make our job properly, and we have to, at the end of the day, take a decision, which is not always easy, and we do our best, as always.
All right, thank you very much. Do you have any questions? Okay, so if there are no questions, many thanks to the panelists. Thank you very much for attending the event, and I wish you a very good rest of the day. Bye-bye.